Good evening. I apologize. The timer function was not working at the top of the show, but hopefully the streaming is working okay. Looks like it is. Welcome, everybody. We're coming closer to the end of the fast today. This is the 17th of the Hebrew month of Tammuz, when we remember the breaching of the walls, when the Roman army came in, breached the walls of Jerusalem. And it would be 3 weeks later on Tisha B'Av, when we do a complete 25-hour fast, that the temple was destroyed. But it wasn't just that the horde, as it were, broke through the walls of Jerusalem on this day. They got in, they went straight to the temple, they desecrated the temple, and from this day forward, the daily service and all the laws and all the obligations and commandments that are associated with it ceased. It ceased on this day in history and was never renewed, right? So for 2,000 years, we've been longing to worship God as he commanded, and a huge part of that is the daily offerings brought in the temple, and that ceased on this day in history. At any rate, I've got a splitting headache. I know a lot of people get the headache when they're fasting, but we'll just try to muddle through and teach today's class. So let's light up the darkness. All right, who's in the house? Stephen in New Hampshire, Paul in Chicago, Renee in Indiana, Melissa in Great Neck, Peggy in Colorado, Belle in Texas, Lucy in Minnesota, Shandor in the Bronx, Sharon just came in from the airport and still fasting. Oh, what a tough day to travel while fasting. My heart goes out to you. Karen in Northern California, Paula in the Great Northwest, Aoife in Florida, Lynn in North Texas, Marie in Freeport, New York. Let's get it going. Okay, we are now in chapter 5, continuing our discussion of rabbinic decrees, rabbinic enactments that were made for tikkun ha'olam, for the betterment of the world. Our first Mishna here in chapter 5 had to do with monetary law, and specifically that if a person owes money and he doesn't have cash on hand, he doesn't have movable assets, and we're going to have to go in, the court is going to have to go in and seize part of his real property, his land, in order to pay this money that he owes. So from which part of his real property will be seized? And the sages recognize 3 categories of land that a person could own. Superior quality, intermediate quality, and inferior quality. So if somebody, for example, if somebody has an ox and the ox, breaks through his fence and starts grazing and even damaging the land of his neighbor, and he can't pay off the debt with money or movable assets, then in that situation, the one whose land was damaged can seize of the superior quality land of the owner of the ox. But when you're just talking about a regular debt, there the creditor is only going to be able to seize from intermediate, and a creditor collects from intermediate quality, and payment of a woman's marriage contract is from inferior quality land, although Rabbi Meir says from intermediate quality land. Then there was also discussion of liened property, and when we can go after, when a creditor who has a lien on real property can go after that property, even if in the meantime, since the loan was made, the one who mortgaged the property to pay it off sold that property, right? So now the creditor, he's only going to be able to go after that mortgage property or liened property if there's no other property available that, some third party hadn't bought in the meantime. Those were among the enactments that were made for the betterment of the world, listed in our Mishnah, here number 1 of chapter 5. So our daf is page 49. Today we pick it up near the bottom of 48b with the Gemara on this Mishnah. When the Mishnah says for the betterment of the world, it seems to be referring to all of the cases in the Mishnah. So the Gemara asks, the first clause of the Mishnah states that compensation for damage is collected from superior quality land. Is this ordinance also made for the betterment of the world? This is not a rabbinic decree. This is a Torah law, as it is written with regard to one who damages another person's property in Exodus 22, verse 4, quote, of the best of his own field and of the best of his own vineyard shall he pay. The sages didn't enact that one who has his property damaged by another and goes after that person's property to collect damages receives from the superior quality land. The Torah itself says that. So how can you say in the Mishnah that these were enactments made by the sages for the betterment of the world? And Abaye answers, this statement is necessary only according to Rabbi Yishmael, who said that by Torah law, we appraise the property of the injured party, the one who's, it's not that we appraise that the one who owes the damages, we go after his superior quality land, but rather the court, in evaluating that this person, his property was damaged, well, which part of his property was damaged? It was his superior quality land. Then we're going to go after superior quality land of the one who caused the injury. But the court makes its appraisal initially based on the property of the one who was damaged, not the one who did the damaging. That's a Rabbi Yishmael, who said that by Torah law we appraise the property of the injured party, i.e. the injured party can collect payment only from property equal in quality to the best of his own land, even if the one who caused the damage owns property of higher quality. Therefore, the Tana of the Mishnah teaches us that for the betterment of the world, we appraise the property of the one who caused the damage, right? So interesting, Rabbi Yishmael was saying that, well, let's say, that my ox broke out of my property and went over to your property and caused damage there, and it damaged the best of your property, right? But let's say that, your property is not such good land, and I, your neighbor, happen to have a much better piece of land. So the best land of your property is only equal to the worst of mine. Are we now going to, compensate you for the damage caused to your land from the best of my property, when we could take from the worst of my property and that would be equivalent to the land that was damaged? So that's what it would be by Torah law. But the sages, for the betterment of the world, said, no, the one who causes damages, we're going to go after the best of his property, even if it's far superior to the best of the property of the one who suffered the damage. Now the Gemara asks, what is this statement of Rabbi Yishmael alluded to by Abaye? It is as taught in a Baraisa, the verse of the best of his own field and of the best of his own vineyard shall he pay, that we saw in the Torah. This teaches that the appraisal is of the best quality of the field of the injured party and of the best quality of the vineyard of the injured party. This is the statement of Rabbi Yishmael. So that could be interesting. Well, what if my ox damaged the worst of your property? Are we going to make an evaluation based on the best of your property, and I have to come up with land equivalent to the best of your property, even if the ox only damaged the worst of your property? It would seem that that is what Rabbi Yishmael is saying. Rabbi Akiva says the verse comes only, that's what Rabbi Yishmael is saying that the Torah says to do. Rabbi Akiva says this verse from the Torah comes only to allow injured parties to collect compensation from superior quality land belonging to the one who caused the damage in the event that he has no money or movable property. And by means of a kal v'chomer inference, one can derive that the temple treasury also collects from superior quality land, right? Kal v'chomer, if in the case of two neighbors, and one is damaged by the other, then the damaged neighbor is able to collect from the superior quality land of the one who caused the damages. Then how much more if the one who received the damages was property that had been consecrated and therefore belonged to the temple treasury. Right? The temple treasury is going to be in the best possible position of any injured party, since we're always so careful to make sure that nothing which is consecrated can be misappropriated in any way. So if one is going to do better by damaging temple property than by, a normal person's property, that would be in a sense like misappropriating property that belonged to the temple, since it's being treated in a less favorable manner. Now the Gemara asks, and according to the opinion of Rabbi Yishmael, if one's animal ate from a rich garden bed, it is understandable that he must pay the injured party the value of a rich garden bed, right? Let's not think about my ox. Let's think that I have, a bunch of goats, and my goats broke out of my property and onto your property and started eating your garden bed, right? Like went right through your nice, beautiful tomato patch, right? So you're obviously gonna be entitled to damages for that. So let's say that you had 3 tomato patches on your property. One was producing lousy tomatoes, one was producing, medium tomatoes, and one was producing beautiful tomatoes. Okay, so if my goats ate your most beautiful tomatoes, well, then you want to be compensated for that. But if, let's say my goats ate from a poor garden bed, right, from your lousy tomato patch, is it reasonable that I would have to pay the value of the rich garden bed, right? If my goats broke into your property and caused damage, okay, I owe you. But just the fact that you have 3 tomato patches and one of them produces superior quality tomatoes, but my goats ate your poorest quality tomatoes, and that's the damage that they caused, do I have to pay you the value of the superior quality tomatoes, even though those were not touched by my goats, simply because you own superior quality tomatoes? Is that what the Torah is saying? That we assess according to your best, the damaged party's best? Rav Idi Bar Avin said, no. With what are we dealing here? We are dealing with a case where the animal that caused the damage ate from one garden bed among other garden beds, and we do not know whether it ate from a poor one or it ate from a rich one. In such a case, the animal's owner pays the injured party the value of the latter's best quality property. Right, so my goats came back with a bunch of tomato juice on their mouths. When we went and looked at your property, we saw that you also own goats, and all the goats got together and had a tomato party. And so it's clear that your goats ate your tomatoes and my goats ate your tomatoes, but we don't know which tomatoes my goats ate. It's possible they ate from the lower quality ones or from the higher quality ones. In that situation, I'm going to have to compensate you as if, because of the doubt, my goats ate from your best tomatoes. Rava raised a question. If we would know that the animal ate from a poor garden bed, its owner would have to pay only the value of the poor garden bed. Now that we do not know from which garden bed it ate, is it reasonable that he should have to pay the value of a rich garden bed? We don't know. And there is a principle governing monetary disputes that we're going to touch on that here in Tractate Gittin somewhat. I'm sure it'll come up a bunch of times. But we're really going to get into it when we really start studying contracts in Bava Kama, Bava Metzia, etc. This comes up all the time, right? That the burden of proof falls on the claimant. Or as the Art Scroll translates it, the burden of proof falls on the litigant seeking to extract money, right? So right now, right, my goats did harm. You want to get payment for damages. So that money that will eventually become payment for the damages, I have it right now. You're seeking to extract it from me, so you bear the burden of proof. You could say, well, my goats have tomato juice on their mouths. Okay, well, that doesn't tell the whole story necessarily. So at any rate, you're going to have to prove whatever is going to be the basis of your argument to remove damages from me. You're going to have to go before the rabbinic court and make your case. It makes sense. The burden of proof rests on the one trying to win the damages. Therefore, so long as the injured party cannot prove that the animal ate from the rich garden bed, he should not be entitled to collect the value of such a garden bed. Right? So in our situation where we said your goats ate from your tomatoes and my goats ate from your tomatoes, and we have no way of knowing which goats ate which tomatoes, you can't say that my goats ate from your superior tomatoes. We probably have to do some kind of an average, right? Now we're actually at the top of 49a. So rather, Rav Acha Bar Yaakov said, with what are we dealing here? We're dealing with a case where, after appraising the damage, the court comes to collect from the one who caused the damage, but it does not have the money available to pay for the damage that he caused. And the Tanaim, the rabbis of the Mishnah, disagree in a case where the superior quality land of the injured party was equal in quality to the inferior quality land of the one who caused the damage. And the one who caused the damage also has land of superior quality. Now, with regard to such a case, Rabbi Yishmael holds we appraise the value of the land of the injured party. And therefore, the one who caused the damage can pay with his inferior quality fields because those fields are equal in quality to the best fields owned by the injured party. And Rabbi Akiva holds we appraise the value of the land of the one who caused the damage and have him pay with his fields of superior quality. It makes no difference whether the injured party has fields of lesser, equal, or greater value than my fields. He suffered a certain dollar amount of damages, and we're going to take from my superior quality land to pay that amount of damages, according to Rabbi Akiva. Now, what is the reason of Rabbi Yishmael, who says that we're going to, if his best land is only equal to my worst land, then we can use my worst land, my inferior quality land, to pay these damages, for the harm that my animal did when it crossed over into his property. What is the reason of Rabbi Yishmael? The word field is stated below towards the end of the verse. Of the best of his own field and of the best of his own vineyard shall he pay. And this word field is also stated above at the beginning of the same verse. If a man shall cause a field or vineyard to be eaten, and shall put in his beast, and shall feed in another man's field. So just as the field in which is stated above belongs to the injured party, so too the field stated below belongs to the injured party. Seems like a good analogy that Rabbi Yishmael is making. And Rabbi Akiva holds, when the verse states, of the best of his own field and of the best of his own vineyard shall he pay, it means from the best of the one who is paying, not the best of the one who is being paid. And how would Rabbi Yishmael respond to this? How does Rabbi Yishmael respond to Rabbi Akiva? The verbal analogy between the two instances of the word field, right? So this is known as a gezerah shava, that we see the same word in two verses that are adjacent to each other, but sometimes we just look at the same word being used, in two separate laws, but because the word is in both places, the sages can draw a link and borrow from one area of the law to another. Here, the verses are adjacent. So how would Rabbi Yishmael respond to this? The verbal analogy, the gezerah shava between the two instances of the word field, is effective. And the straightforward meaning of the verse itself is effective. The verbal analogy is effective. As we read, it serves to teach that when it says he pays from the best of his field, it means from the land equal in quality to the best field owned by the injured party, who is the one whose field was harmed, right? In the same verse, it's talking about him. And the straightforward meaning of the verse itself is effective, as it serves to teach a different law. Namely, that if one who caused the damage has superior quality land and inferior quality land, and his inferior quality land is not as good as the superior quality land belonging to the injured party, then the one who caused the damage pays the injured party from his best land, i.e. from superior quality land that he owns. Now, the Baraisa teaches that Rabbi Akiva says the verse comes only to allow injured parties to collect compensation from superior quality land belonging to the one who caused the damage, no matter whether that land is better, equal to, or worse than the one who was injured. Right? Rabbi Akiva says it makes no difference what the comparison is between the land owned by the two people. The fact is, the one who causes damage, we go after his superior quality land when we're getting compensation for the one who was injured. And by means of a kal v'chomer inference, one can derive that the temple treasury collects from superior quality land. So the Gemara asks, what is the kal v'chomer inference from ordinary damage to damage involving the consecrated property? How are we going to extend a ruling? Because normally we'd say, well, if ordinary property is protected by this measure, then consecrated property, all the more so is it protected, right? That's the standard kind of kal v'chomer inference that we would make in such a situation. But does it actually apply? What is the kal v'chomer inference from ordinary damage to damage involving consecrated property? To which case does this refer if we say that our ox, meaning an ox belonging to a Jew, gored an ox that is consecrated property? Well, then there is a difficulty. Right now we're talking about, now we're not talking about land, we're talking about my ox gores your ox. That's the first case, right? So if my ox gores your ox, I'm going to owe you money. How much is going to be the question, right? Now, we're going to make a distinction between the innocent ox and the habitual gorer, right? So an ox that has been known to attack other oxen, and it did it once, and then it did it again. Are we having sound problems? Did this get fixed? Hopefully the sound is okay. You'll let me know. The video seems to be flowing okay, so hopefully it's all right. Okay, so you'll let me know. Where am I? Right, so the habitual gorer, if it has been known to gore other oxen in the past, and I was negligent in allowing this dangerous animal to get out and attack other oxen, so then you can see why I would be, liable for a greater measure of damages than if I owned an innocent ox, meaning that ox never caused problems before. I would have no reason to think it requires additional safeguards. Okay, so what are we talking about here? Where am I? If we say that our ox, right? So an ox belonging to an ordinary Jew, gored an ox that is consecrated property, right? So now we're talking about an ox that really doesn't belong to another Jew. I have my ox, right? And my neighbor Reuven has his ox, but Reuven consecrated his ox. Meaning that he said he's going to donate that ox to the temple treasury for the upkeep of the temple. So now he is, that ox might be on his land and he's going to feed it and take care of it, but he can no longer do work with it. He can't slaughter it or make use of it because that ox now belongs to God, as it were. It has been given to the temple. So if my ox gores this ox, it's not Reuven's ox anymore. Reuven is taking care of this ox that he consecrated. It now belongs to the temple treasury. Okay, so what's going to happen? So if we say that my ox gored a consecrated ox, there is a difficulty. As the merciful one states, and if one man's ox hurts another person's ox, Exodus 21:35, and then what the outcome would be, whether it's an innocent ox or a habitual gorer. Well, this teaches that the law applies only if the ox hurt an ox belonging to another person. But that ox is not Reuven's ox anymore. Now it's a consecrated ox. It doesn't belong to any individual person. And so therefore, no damages would be collected, right? And you could sort of see the logic of it. It's the same thing as if Reuven had declared his ox ownerless, right? That now nobody owns that ox, and my ox gores it. Well, that's unfortunate for the ox that was gored, but it doesn't belong to any person. So no person comes in to collect damages from me because my ox gored that ox. And likewise, if my ox gores a consecrated ox, that's a loss for the temple treasury. That ox is, not worth as much as it was before. Maybe even it's dead. But that ox doesn't belong to an individual. And the Torah came to say that that damage is paid when one ox gores another is because somebody's ox gored somebody else's ox, and the consecrated ox doesn't belong to any individual. So what is the Kal V'chomer inference, right? How can we talk about consecrated property? So rather, we say that the Kal V'chomer inference is not referring to a case of damage, but rather to one who says, it is incumbent upon me to donate 100 dinars for temple maintenance. And the inference teaches that if the one who took the vow has no money, then the temple treasurer comes and collects the 100 dinars from his superior quality land. In a sense, when you make a pledge to donate money to the temple treasury, then until you donate it, the treasury is like a creditor, and the one who made the pledge is like a debtor. So if the temple treasury has a right to come in and appropriate land in order to pay off that pledge, then it's going to be able to do so from superior quality land. But the Gemara challenges this understanding. The temple treasurer should not be treated any better than an ordinary creditor. And as stated in the Mishna, the law of a creditor is that he collects only from intermediate quality land. So how can you say that the temple treasurer coming to, make good on a pledge that a person made to donate money to the temple treasury would be able to seize superior quality land if creditors generally collecting on a debt can only seize from intermediate quality land? And if you would say that Rabbi Akiva holds that even a creditor can collect the money owed him from superior quality land, like payment for damages, right? The Mishnah said that when it's just a debt, we collect from intermediate quality land. When we collect for damages, then we can collect from superior quality land. So, but even if you would say that a creditor can collect from superior quality land, like the one who's collecting payment for damages, we would still have a difficulty establishing this Kal V'chomer inference with regard to consecrated property, because the Kal V'chomer inference can still be refuted. If an ordinary creditor can collect the money owed him from superior quality land, this is because the Torah enhanced his power with regard to payment for damages, as a common person can collect payment for damages caused by another person's ox. But can you say the same about the temple treasury, with regard to which the Torah weakened its power with regard to payment for damages, not allowing it to collect such compensation at all? Where are we going to learn that the temple treasury actually has some kind of a superior position that the Kal V'chomer would apply to it, if we see from the law of the ox that an individual can collect, certain damages when his ox is gored, but the Torah only said that for an ox that's owned by a person, not for an ox that is ownerless or that is owned by the temple treasury. But the Gemara rejects this challenge. Actually, we can explain that we are dealing here with a case where an ordinary Jew's ox gored an ox that is consecrated property. And Rabbi Akiva holds in accordance with the opinion of Rabbi Shimon ben Manasseh with regard to this issue. As it is taught in a baraisa that Rabbi Shimon ben Manasseh says, if an ox that is consecrated property gored an ox belonging to a common person, okay, reverse situation, Reuven consecrated his ox. He's taking care of it until he can actually give it to the temple treasury. That consecrated ox broke out, or, he left the gate open, and it came and gored my ox. Okay, well, now who pays, right? Maybe, let's just say that it wasn't Reuven's negligence that caused this, right? Reuven did what he was supposed to do. He doesn't own the ox. Let's say he even already turned it over to the temple treasury. So it really was the temple treasury's ox that gored my ox. Okay, then what happens? So if a consecrated ox gored an ox belonging to a common person, the temple treasury is exempt from liability. Oh. By contrast, if an ox belonging to a common person gored an ox that is consecrated property, whether the ox that gored the other ox was an innocuous ox, right, the innocent ox that hadn't gored before, or if it was a forewarned ox, right, the habitual gorer, and the owner is forewarned because of that history. In either case, the owner, right, so if it's an innocent ox, right, no reason to suspect that it will cause damage, you just pay the damage. If it's a habitual gorer, you pay triple damage because you should have been much more careful with such a dangerous animal. But in either case, the ox's owner pays the full cost of the damage. Okay, so according to Rabbi Shimon ben Manasseh, the temple treasury is in a wonderful position. If the temple's ox gores my ox, I get no damages. If my ox gores the temple's ox, I pay the full damages. If it's an innocent ox, just the damages. If my ox is a habitual gorer, the triple damage. But the temple treasury gets paid, but doesn't have to pay. Now that is not so surprising. Because, for example, if you're a contractor doing construction for the temple, then when you're estimating what you need to be paid, we round down, lest a mistake be made and I take money from the temple that I wasn't really entitled to, which would be misuse of consecrated property, and that's a sin. So to protect me from that, they would round down. On the other hand, if I owe money to the temple for some reason, I'm actually like a contractor who performs services, and I... And whatever, I'm an insurer, I'm an insurance company, there was a claim on the temple, something was damaged, I have to pay the temple the money, the Holy Temple the money. There we're going to round up to make sure I overpay a little bit, because if, I mistakenly underpay a little bit, that's misuse of consecrated funds. So maybe there's that kind of non-reciprocal relationship with the holy also exists in this case. So according to Rabbi Shimon ben Manasseh, right, the temple's ox, if it causes damage, the temple doesn't pay. If it gets damaged, we pay. So the Gemara asks, if so, from where do you know to say that Rabbi Akiva and Rabbi Yishmael disagree about a case where the superior quality land belonging to the injured party is equal in quality? Wait a minute. Yeah. Okay, so that's right. Okay, so the Gemara asks, so if so, right, because now we sort of, if so, from where do you know to say that Rabbi Akiva and Rabbi Yishmael disagree about a case where the superior quality land belonging to the injured party is equal in quality to the inferior land belonging to the one who caused the damage? And the one who caused the damage also has land of superior quality, as the dispute was previously interpreted by Rav Acha bar Yaakov. Perhaps everyone, including Rabbi Akiva, agrees that we appraise the value of the land of the injured party, and here they disagree with regard to the dispute between Rabbi Shimon ben Manasseh and the rabbis. And the Gemara explains, as Rabbi Akiva holds in accordance with the opinion of Rabbi Shimon ben Manasseh, that in the case of damage caused by a regular person's ox to the property of the temple treasury, compensation is collected from superior quality land belonging to the one who caused the damage. And Rabbi Yishmael holds in accordance with the opinion of the rabbis that the owner of the ox bears no liability. Okay, so you see that. So Rabbi Shimon ben Manasseh says, if my ox gores the temple's ox, the consecrated ox, so then I owe damages, and therefore the court can come and take from my superior land because what? Because you can take from superior land when you owe damages, as opposed to simple debt. And if you're going to evaluate and then we had this disagreement between Akiva and Yishmael about, well, when we're talking about superior quality property, are we talking about the superior quality property of the one who caused the damage or the superior quality property of the one who was damaged? If we say that the one who was damaged is the temple, right, because the temple owns the consecrated ox, Okay, well, there is no land more valuable than the Temple Mount, right? There is no land of higher quality than the land underneath the Holy Temple, that axis, right, that joins heaven and earth. So, if it's the land belonging to the injured party that we evaluate their superior quality land, okay, well, nothing is superior to that. So, of course, we're going to go to my most superior quality. On the other hand, the rabbis who disagree with Shimon ben Manasseh say that in the case of an ox, a consecrated ox that is damaged, no damages are paid because that ox is not owned by a person. So if no damages are paid, then okay, what difference does it make whether I have superior quality land or not? I'm not paying damages. And Rabbi Yishmael, right? So Rabbi Akiva holds in accordance with Rabbi Shimon ben Manasseh, right? That we do pay, and therefore we can get from my superior quality land. And Rabbi Yishmael holds in accordance with the rabbis who say I don't have to pay at all. But the Gemara rejects this suggestion. If it is so that this is the disagreement between Akiva and Yishmael, then what is the meaning of Rabbi Akiva's statement that the verse comes only to allow injured parties to collect compensation from superior quality land? Now, we're still arguing about whose superior quality land, the injured party or the injurer. But here the Gemara is saying the verse that Akiva said the verse comes only to allow injured parties to collect compensation from superior quality land. Now, this indicates that Rabbi Akiva disagrees about how to understand this verse. And furthermore, if the subject is the temple treasury, what is the meaning of, and by means of a kal v'chomer inference, one can derive that the temple treasury of consecrated property collects from superior quality land. And furthermore, didn't Rav Ashi say, and now we're on 49b, it is taught explicitly in a baraisa, the verse, of the best of his own field and of the best of his own vineyard shall he pay, teaches that the appraisal is of the best of the fields of the injured party and of the best of the vineyards of the injured party. This is the statement of Rabbi Yishmael, right? So Rabbi Yishmael is saying we're going to appraise the one who is injured. And according to the best of his land shall he receive compensation. But if the best of his land is only equal to the worst of the injurer's land, then the injurer can give damages from his inferior quality land. Rabbi Akiva is the one who came to say that no, and for the betterment of the world, we're always going to take from the best quality land of the one who causes the damages, and this will have the general effect that people will be more careful not to cause damages, right? Rabbi Akiva says the appraisal is of the best of the fields of the one who caused the damage and of the best of the vineyards of the one who caused the damage. And this clearly indicates that according to Rabbi Akiva, compensation is collected from the superior quality land belonging to the one who caused the damage. Ravina said, actually, the Mishna is in accordance with the opinion of Rabbi Akiva, who said, by Torah law, we appraise the property of the one who caused the damage. And it is also in accordance with the principle of Rabbi Shimon, who expounds the reason underlying the verse as a basis for drawing halachic conclusions. And the Mishnah is saying, what is the reason for the law taught in our Mishnah? The Mishnah should be understood as follows. What is the reason that the court appraises land of superior quality for payment to injured parties? This is for tikkun ha'olam, for the betterment of the world. And that is to say, the words for the betterment of the world do not merely indicate that it was a rabbinic enactment. Rather, they provide a reason for the Torah law, the underlying Torah law. And this is as it is taught in a baraisa that Rabbi Shimon said. This is Rabbi Shimon's view. For what reason did the sages say that the court appraises land of superior quality for payment to injured parties? It is due to the robbers and due to those who take that which is not theirs by force, the hamsanin. How so? So that a person will say, why should I rob and why should I take by force Tomorrow the court will come down to my property and take my finest field in order to compensate the victim for what I have robbed or taken by force. And the sages rely on that which is written in the Torah. Of the best of his own field and of the best of his own vineyard shall he pay. Consequently, they said that the court appraises land of superior quality for payment to injured parties, meaning the best quality land of the one who causes the damage. Right? So Rabbi Akiva is saying that the sages enacted that we appraise the best quality land of the one who caused the damage in order to pay what he owes for the injury that he caused, and that this was instituted by the sages for the betterment of the world. Rabbi Shimon is saying that's the interpretation of the sages, but it was instituted by the Torah for the betterment of the world, that we take of the finest land. You could have understood that the Torah itself demanded that. Now the Baraisa continues. For what reason did the sages say that a creditor collects his debt from intermediate quality land? Okay, now we're moving away from damages and to debtor-creditor. For what reason did the sages say that a creditor collects his debt from intermediate quality land? It is so that a person should not see another's fine field or fine house and say, I will jump in and lend him money, so that later I will collect the field or the house for my debt, if the borrower does not have enough money to repay the loan. Therefore, the sages said that a creditor collects his debt only from intermediate quality land, and he would not receive the fine field that would have prompted him to extend the loan in the first place. And from a point of view of just kind of equity and justice, it kind of makes sense, right? If I'm just minding my own business, running my life, and your goats break out of your yard and into my yard because you didn't have a good enough, fencing to keep your goats in, and they cause my yard all kinds of damage, okay, then I should be like right at the head of the line to be compensated for that because I didn't involve myself in any situation that could lead to my damage. This is totally your fault. On the other hand, if I lend you money, okay, well then I am entering a business relationship with you, and I entered this with my eyes open, right? Now, of course, the parties can stipulate in the contract, where payment is going to be taken from if, the money payment is not made, right? And that's what we're talking about, a lien or a mortgage, etc. But in the absence of such stipulations, when I take you to court because you owe me money, where can I get the damages from? Where can I get the debt repaid from? Your intermediate quality land. Not your best, not your worst, but medium. So the Gemara asks, if it is so that the objective of establishing creditor-debtor law this way, that the creditor can only take from intermediate quality land to satisfy the debt, if it is so that the objective is that people not be tempted to lend money for the purpose of acquiring the borrower's finest property should he default on the loan, then the law governing a creditor should be to collect his debt from inferior quality land. And the Gemara answers, well, if so, then you would be locking the door before potential borrowers. If lenders could only recover the money that is owed to them from the worst quality land, then they would be much less quick to lend money, right? So you want to promote that poor people can borrow money when they need it, and that's why you establish that creditors can seize neither the best land nor the worst land, but the intermediate quality land for repayment of loans. Now the Baraisa continues, payment of a woman's marriage contract, her ketubah, is collected from inferior quality land. This is the statement of Rabbi Yehuda. Rabbi Meir says it can be collected from intermediate quality land. Rabbi Shimon said, for what reason did the sages say that a woman's marriage contract is collected from inferior quality land? It is because more than a man wants to marry a woman wants to become married to a man. Consequently, she will agree to marry even if she knows that she will not be able to collect payment of the marriage contract from superior quality land. In other words, what they're saying is, in the same way that we wouldn't want to discourage lenders from lending money by saying they only have access to the lowest quality land, and we wouldn't want to encourage, sharpsters who will lend money to people just so that they could, create difficult terms and ultimately seize their finest land. And that's why we put them in at intermediate land. Here, they say that, like, women would like to be married more than men do. So you want to create incentives for men to enter into marriage. And that's why they drew it up in this way. Now, alternatively, it is because a woman is sent out from her husband with or without her consent, but a man sends his wife out of his house only with his consent, meaning that a man instigates divorce under Jewish law, not the woman. Now, the Gemara immediately asks, what is the reason that the Tana of this Mishnah mentions an alternative explanation? What problem is there with the first explanation about incentivizing the husband to enter into marriage? And the Gemara answers, the alternative explanation does not explain why she collects from inferior quality land, but serves to explain a different matter. Since the sages instituted a marriage contract in order to strengthen the institution of marriage. Recall that the sages created the ketubah. The Torah doesn't speak about a ketubah at all. But the sages instituted the ketubah to protect women because the husband can divorce them at will. By the way, that law also eventually changed. Rabbi Gershon instituted that the husband can't divorce the woman without her consent. She participates in that. A husband can withhold a divorce, but he can't just divorce her without her having any say in the matter. So if you would say that just as when a man divorces his wife, the sages instituted a marriage contract for her from him, so too when she leaves him, they should similarly institute a marriage contract from her. Then come in here. A woman is sent out from her husband with her consent or without her consent, but a man sends his wife out from his house only with his consent. Even if she instigates a quarrel with him to bait him into divorcing her, it is nevertheless possible for the husband to keep her waiting for a bill of divorce. A man gives his wife a bill of divorce only when he wishes to do so, and so in essence the divorce depends solely on him. And that's why, for example, if there was a rich woman and a poor man, right, and she baits him into divorcing her, he doesn't, receive property from her just because they were married under Jewish law. In California, it might be a different outcome, but under Jewish law, the ketubah only goes in one direction. Again, you can make stipulations that are different, but the standard ketubah flow protects the woman. Now, the Mishnah teaches that payment of a woman's marriage contract is collected from inferior quality land. Mar Zutra, the son of Rav Nachman, said, we said that a woman collects her marriage contract from inferior quality land only when her husband died and she collects payment from the orphans who inherit the estate. But if she was divorced and she collects payment from the husband himself, then she collects from intermediate quality land just like any creditor would. And the Gemara asks, if the Mishnah is referring to collecting from orphans, then why discuss specifically a woman's marriage contract? Even all matters, such as payment for damage, should also be collected from inferior quality land when it is collected from orphans, because we protect orphans since they can't protect themselves. As didn't we learn in the Mishnah, if one who owed money died and his children inherited his property, the father's debt can be collected from the property of the orphans only from inferior quality land. So rather, is it not that the Mishnah is referring to a case where the woman collects her marriage contract from the husband himself? The Gemara rejects this argument. No, actually, the Mishnah is referring to a case where the woman collects her marriage contract from the orphans who inherit their father's estate. And it was necessary for the Mishnah to teach the law specifically with regard to a woman's marriage contract, as it might enter your mind to say that the sages were more lenient with her for the sake of desirability, meaning so that she would be a more desirable partner should she want to remarry, so that she would bring some assets to her next marriage. And consequently, they allowed her to collect payment of her marriage contract from intermediate quality land, even from orphans. Lest you think that, the Mishnah teaches us that even payment for a woman's marriage contract is not collected from the intermediate quality land of orphans, but only from their inferior quality land. But generally speaking, if a woman is collecting her ketubah after a divorce, not after she becomes a widow, but after a divorce, then she does go after the husband's intermediate quality land, not inferior. She only gets from inferior quality land if she's claiming from the estate of the husband because she became a widow, and therefore she's taking property that would otherwise belong to the orphans. Rava said, come in here a proof from a baraisa. Rabbi Meir says payment for a woman's marriage contract is collected from intermediate quality land. The Gemara attempts to clarify the case. From whom does she collect payment of her marriage contract in this case? If we say that she is collecting from the orphans, it is possible to ask, does Rabbi Meir not agree with that which we learned in the Mishna, that the father's debt can be collected from the property of orphans only from inferior quality land? Rather, is it not that the woman collects payment for her marriage contract from the husband himself, meaning a divorce, not a widowhood? And since Rabbi Meir maintains that she collects from intermediate quality land, one can learn by inference that the rabbis hold that she collects from inferior quality land, contrary to the opinion of Mar Zutra. Mar Zutra says she collects from intermediate quality land in a divorce, but it seems that the majority maintain that no, she always collects from inferior quality land. But the Gemara rejects this argument. No. Actually, it is possible to explain that the baraisa is referring to a case where the woman collects her marriage contract from the orphans who inherit their father's estate. And payment of a woman's marriage contract is different from other debts collected from orphans. Right? So here they're saying that even if she's collecting from orphans, she takes from intermediate quality land as opposed to all other creditors of the father who come to collect from the estate who can only collect from inferior quality land. Payment of a woman's marriage contract is different from other debts collected from orphans. The sages were more lenient with her for the sake of desirability, so that she can remarry with some assets to her name. And Rabbi Meir ruled that she may collect her marriage contract from intermediate quality land even if she is collecting from orphans. Abaye said, come in here a proof from that which is taught in the Mishnah. The court appraises land of superior quality for payment to injured parties, and a creditor collects from intermediate land. And a payment of a woman's marriage contract is collected from her husband's inferior quality land. So the Gemara attempts to clarify the case. From whom is the collection being made? If we say that in all of these cases, collection is being made from orphans, why mention specifically a woman's marriage contract? All cases of collecting from orphans take from inferior quality land. Rather, is it not that the Mishnah is referring to a case where the woman collects her marriage contract from the husband himself? And the Mishnah says inferior quality land. So maybe it's not that the woman takes from intermediate quality land unless she's taking from the estate, but rather that a ketubah only entitles her to take from the husband's inferior quality land, even in the case of a divorce when the husband is still alive? Question mark. Rav Acha Bar Yaakov said, no proof can be brought from the Mishnah against the opinion of Mar Zutra, who said that she collects from intermediate quality land unless it's in the case of orphans. With what are we dealing here? We are dealing with a case where one became a guarantor for compensation for his son's damages, and similarly for repayment to his son's creditor, and similarly for payment of his daughter-in-law's marriage contract, and his son died. So we have the young son of a rich man. And everyone just assumes that if the son causes damage, his father will pay. If the son owes money, the father will pay. And if the son divorces his wife, the father will pay. Right? Because the father is the guarantor. Perhaps that is the case that we're talking about in all the three cases of the Mishnah. Since the guarantor stands in the place of his son, collection is made from him as if it were being made from his son. And payment is made in this case in accordance with its law, and payment is made in that case in accordance with its law. Since an injured party and a creditor ordinarily collect from those who owe them money while they are alive, when the guarantor pays the debt, he too pays the debt as though the one who caused the damage or borrowed the money were still alive. Therefore, in those cases, collection is made from superior quality for damages or intermediate quality land for debt. But in the case where the father serves as a guarantor for his son, payment of a woman's marriage contract is only after her husband's death, and after his death, from whom does she collect? From the orphans, right? In the case of a husband who died, always you look to the estate, right? And that means the orphans. Consequently, when the guarantor pays the debt, he too pays the debt as though it were being paid by the orphans after the husband's death. Accordingly, payment for her marriage contract is made from inferior quality land if we're talking about a husband who died and we're extracting money from the orphans, even though there's a guarantor, and we're not actually taking money from the orphans, but the guarantor, so to speak, stands in the same place as the original, borrower or damager, or in this case, husband would have stood. So the Gemara asks, but let him derive this law from another law that states that the guarantor of a marriage contract does not become responsible for the payment of the marriage contract from his own property. The signature that he adds to the marriage contract serves merely as additional support, but does not turn him into a true guarantor. Therefore, even if a collection is made, it is only from the inferior quality land. And the Gemara answers, we are dealing here with an unconditional guarantor, one who accepted unconditional responsibility for the obligation, allowing his daughter-in-law to collect payment of her marriage contract either from his sons or from him as she so desires. I'm very close to done. Questions or comments, get them in. The Gemara asks, this works out well according to the one who says that an unconditional guarantor becomes responsible for payment of the loan even if the borrower does not have property of his own. Therefore, it works out well to explain the case in this manner. But according to the one who says that if the borrower has property of his own at the time of the loan, then the unconditional guarantor becomes responsible. But if the borrower does not have property of his own at the time of the loan, then the unconditional guarantor does not become responsible. What is there to say in a case where the son did not have any property at the time of the marriage? In such a case, the father never became responsible for the son's obligations. And the Gemara answers, if you wish, say that it is a case where the son had property of his own at the outset, but afterward it was blighted. Since the son had his own property, the father accepted responsibility for the obligation, and now that the property has no value because it was blighted, the daughter-in-law can collect payment for her marriage contract from her father. And if you wish, say, with respect to anything relating to a son, it is common for a father to pledge himself absolutely, even when the son has no property of his own. That's where we're going to knock off today. With God's help, we'll be together again tomorrow, Friday, at the regular Friday time, noon Pacific. I do have a dental appointment at 11 to remove these sutures from my gums. And if all goes well and there's no traffic in LA on a Friday, I'll get back in time to start the show at noon. But slightly possible that I'll be a little bit late getting started tomorrow for that reason. Okay, couple of questions. This is when I would take a drink of water, but it's a fast day. Bill, this brings up a question that I don't know I've ever thought of because it's so enmeshed in modern legal context that I never even considered that it might not be so in the Torah. What, legally speaking, is a person? For example, is there such a thing as an entity which is a legal personage like a corporation or a foundation? We certainly will get into partnership law, right? Where partners co-own something, and then do they share liability if one of the partners causes the damage, etc. I don't know that they had a corporate law, forming an entity that has its own, that has its own obligations and rights, and which shields the owners of that corporation from liability. But as we see that the temple sort of does act like an entity in that sense, or the community can act as an entity in that sense, and it's treated sometimes like a person and sometimes not. Sharon, who evaluated the quality of the land? Wonderful question. It says that the court appraises I would think that either the judges of the court are, adept enough at conducting a financial appraisal that they do it themselves, or they would bring in some kind of expert. And Lucy, does the law assume that the orphans are always minor children and hence vulnerable? What a good question. It hasn't been addressed yet. And I don't think that there is an assumption that they are minors. They're going to be vulnerable anyway, even if they're adults, right? There is going to be special treatment of orphans in the sense that they step in as inheritors of the estate, and we're going to protect them. And you can see that even if they're sophisticated adults, even if they are lawyers and bankers themselves, they might not know everything that their father had done, the contracts that the father had made, the debts that the father had incurred. They can't know that at the time that they step in and become inheritors. And since they stand in the place of the father, we want to be protective of them because, who knows what the father did. And now the son is going to have sudden, instead of inheriting a nice fortune or even, a modest amount, what he might inherit is debts and liabilities and all kinds of problems, right? And so we're going to be very protective of that. That's what I've got for us today. With God's help, see you tomorrow as close to noon Pacific as possible. For those fasting, may it be a meaning